Welcome everyone. Today we're going to be talking about California break law compliance, and on here we have Amber Healy with Atkinson and Andelson, and I am Barima. I'm the founder and CEO of Timeero, and so again, this webinar is going to be strictly on California break law and compliance. So great to have you here, and thanks for joining this, Amber.
Yeah, thank you so much for having me. So I am Amber Healy. I'm a partner at Atkinson Andelson. I practice exclusively in the area of employment law and have been practicing in the area of wage and hours specifically for the entirety of my career. I spent about 8 years representing employees in these types of lawsuits. In the last 10 or 12 years, I've been representing only companies and management. My firm has 9 offices throughout California, so we represent businesses throughout the state. Just a reminder that today's webinar is really informational purposes only. It doesn't create an attorney-client relationship, and none of the information that is provided should be relied on as law. If you have a specific issue in your organization or company, you should work with your counsel, or feel free to reach out to me and we can talk about it outside of the webinar, obviously. But the webinar today doesn't create an attorney-client relationship and should not be relied on for legal propositions that are shared today.
Okay, we're set.
All right. Okay, so let's start with how wage and hour laws are enforced in California. We have private civil lawsuits. So that's when employee A sues company B about something related to their employment. Typically in the wage and hour context, the way that we see those cases filed is either as a class action or another group action, which is known as the Private Attorney General's Act. And that is also referred to as PAGA. That is something that is specific to California. California is the only state who has a PAGA type law, and I'll talk about why that matters a bit today. The other way that wage and hour laws are enforced are through administrative agencies. And so we have the Federal Department of Labor, and we also have the Division of Labor Standards Enforcement, which is also known as the Labor Commissioner. The Department of Labor is the federal agency, so they enforce federal law, and they're present in every state in the country, not just in California. And they actually do not enforce meal and rest break requirements, because meal and rest break requirements come only from California law. So if an employee is making a meal and rest break claim through an administrative agency, they would be doing that through the Labor Commissioner's office. And then I just have over here on the side for you the emblems of the two agencies. And that photo of the guy in the purple suit is I want to say he's a friend. He's an adversary of mine. He has billboards all over the state of California. He calls himself Mr. Justice. His first name is actually Edwin, and he files only wage and hour lawsuits, and he is the top filer, meaning he files the highest number of wage and hour lawsuits in the state of California of any attorney. So if you're wondering why are we spending time talking about meal and rest breaks and wage and hour issues, these are really the statistics that help us understand why we're here today talking about it. So the first graph here, it shows you from 2012 to 2021, the number of employment cases that were filed nationwide. Now, this is only looking at federal filings. So those are lawsuits that are filed in federal court. California's employment law filings are probably much higher than this. But you can see there's still, nationwide from 2012 to 2021, we've had, upwards of 26 to 30,000 lawsuits filed. And in California, there's usually, I would say, probably about 50 new employment lawsuits that are filed each day, and half of those are wage and hour. You'll see on that graph that there's actually a dip in 2020 and 2021, and that is the result of the pandemic. People were really focused on, trying to stay healthy, care for people, have their kids doing remote schooling. And so we saw the result of that is people were focused on things other than, things, they had grievances about work. They were more just trying to keep their job. And so we have a dip that happens as a result of the pandemic. And if we were to extend it out to 2022, 2023, I think you would see it actually is probably much higher. So we're probably closer to about 28,000 in the last 2 years that were filed. So we've actually had a correction there. And then our other numbers here, just to give you some context. The Department of Labor publishes on its website a lot of information about what they're doing to help workers. And so this is a graphic that's from their website. So in 2021, they helped almost 200,000 workers throughout the country. About 9% of that was in California. So even though we only have limited federal laws that apply in California, there's still California claims still make up about 9 to 10% of the claims and charges that are being handled by the Department of Labor. And they recovered more than $230 million in back wages. And they launched almost 25,000 compliance actions where the Department of Labor, like the IRS, comes into businesses, asks for your records and investigation, and then can hit you with fines, penalties, and back wages. This is additional stats that the Department of Labor publishes. So you can kind of see they target specific industries. So they don't actually have to have a complaint, neither does the Labor Commissioner in the state of California. They don't have to have a complaint by an employee in order to investigate and do an audit of a business. Realistically, they have limited resources, so that's usually how it comes to be. But you can see here, sort of, these are the low wage, high violation industries that have been on the target list for both of the administrative agencies. And that matters because when the administrative agencies say, hey, we see that construction has a huge problem here, because as you can see from this chart, almost $33 million in back wages were collected from construction companies by the Department of Labor. So that tells the private attorneys that are working in this area of wage and hour, hey, construction companies have a problem, let's target them. We also can look at food services, a really high number there with 27 million. So these are things that kind of tip off also the private attorneys of what industries they might want to target getting clients from. Just another way that the Department of Labor tries to make their graphics on their website very easy to look at and understand for employees. And I focus really on the Department of Labor for this because they've done a really good job over the last 3 or 4 years marketing what they can do to help employees. And they also developed and released an app that can be downloaded. So if you go to the Department of Labor's website, they have an app where employees can download a timekeeping app that they use on their own, separate and apart from their employer's timekeeping system, to track their hours. And it will tell them, you know, based on the time that you put into the Department of Labor's app, you should have received 40 regular hours, 2.5 overtime hours, and your overtime rate should have been, you know, X. And that helps employees know whether or not they're being paid correctly, but it also is something that employers should be aware of, that there are, you know, things that are very easily and readily and freely available. Of course, that information then is retained. It's an app developed by the Department of Labor, so it is retained by them. So if they see that, you know, somebody's putting information into this app and it doesn't match what they're getting paid, it might be a reason for them to try to find out more information. And the other, so it's very hard to actually get information. Unlike the Federal Department of Labor that puts out all this information, the California Labor Commissioner's Office does not release information very easily. So we look, the most comprehensive review of it was done back in 2016, and it was looking only in San Diego, the claims that were filed. So you can see the types of claims that are very often filed with the Labor Commissioner are regular regular wages, and then overtime, meal and rest breaks trail right behind that. Now, if we were looking at lawsuits, you would find that usually overtime is the prime. Overtime and meal breaks are the top two when we're talking about private lawsuits. But when someone files with the Labor Commissioner's office, typically they are not represented by counsel. So again, when we're talking about the private lawsuits, which is really the biggest issue employers face, we're talking about individual lawsuits. So that's where John Smith sues company A about his own specific experience. And then on PAGA lawsuits, it's a group action. Class actions are another type of group action. And I put an old time clock there to hope that none of you are using anything that's like that. So how do wage and hour lawsuits, especially those involving meal and rest breaks, how do they get really expensive? So a class action is a procedure that allows one employee to sue on behalf of all other typically hourly employees in California. And so what happens is that one employee, they may have only worked for the company for 1 week, 2 weeks, 1 month, and they say, you know, I wasn't paid everything I was owed. I didn't get my meal periods. And when I didn't get my meal periods, I didn't get the premiums. And they say, I want to sue for myself, but I also want to sue for all of the other employees that the company has had over the last 4 years. And so we're looking at an employee group that consists of all of your employees for a 4-year period. So if you're a high turnover industry, even though you only have maybe 50 active hourly employees at a time, over the last 4 years, when you add it all together, you might be looking at something closer to, you know, 200, 250 employees, and the damages then, you know, they're exponentially increased because you now, instead of having one person suing you, you really have 250 people that are part of this lawsuit. A PAGA case is a representative action. It is, like I said, a very unique thing to California, and it allows an employee to recover civil penalties only, and it has a 1-year look back period. So class action is 4 years and includes wages. A PAGA action is penalties and is only 1 year of a look back period. Let's see, I think I covered most of this, but the main thing is combining claims for a class action. You have just a few hundred employees. We're talking about often a multi-million-dollar price tag to settle or resolve the case. And I'll go over how that happens in one of our slides a little bit later. The issue with meal and rest breaks and a lot of other wage and hour issues is that they're really hair trigger liability. That means you could have made an honest mistake. You could have made every effort to comply. You could have been trying and still got it wrong, or not realize that you had employees taking meal periods at, you know, 5.2 hours rather than before the 5th hour. And as a result of that, these are lawsuits that are really employees sue first and then ask question later, because they file the lawsuit and then they're entitled to get all of your records for all of your employees. And that allows them to identify issues that they may not have otherwise been aware of. So PAGA, like I said, it stands for the Private Attorney General's Act, and it was enacted in 2004. It is a lawsuit that allows employees to recover civil penalties for labor code violations that were previously only recovered by the state. So in 2003, the legislature in California said, hey, we don't have enough resources to enforce our laws, and we have all of these laws that say that the state can only recover a penalty for this violation. We're going to go ahead and change that, and we're going to allow private attorneys and private plaintiffs to step into the shoes of the state and pursue what we call a PAGA action. And it's where one aggrieved employee or two sue on behalf of all other aggrieved employees as that group action, talking about all of your employees for about a 1-year period. And because these are penalties that were previously only recoverable by the state, we're going to require that 75% of the recovery in this type of lawsuit goes back to the state of California, and only 25% of it actually finds its way back to the employees. So I get questions of, I hear a lot about PAGA, how bad could it really be? So this is another, I really like the statistics, as you can see, so that's why I'm sharing this with you. And I think it helps put it in context as well. So before a PAGA lawsuit can be filed, an employee, usually through their attorney, has to file a letter basically with the state Labor and Workforce Development Agency, which is the LWDA. That it's not done through an online portal, and it's actually a searchable database. So if you go to Google and you put in PAGA database, you'll get a link to go be able to put in a company name, and you can see the PAGA letters that they've received regarding that company. You can see from 2016 to today, it's been a steady increase, except for we have a blip in 2022 where it dipped down to, below the other years, or, we had an abnormality there. And that's really easily explainable. So in June of 2022, we had the US Supreme Court decide a case called Viking River, where they said PAGA claims could be forced into arbitration on an individual basis. And so as a result, this group part of PAGA there was an issue as whether or not these group claims really existed or it was an individual claim. If it's an individual claim, it's not worth nearly as much as the entire group. And so we had a dip in the filings, and then the California Supreme Court this year in July, so about 13 months after the US Supreme Court, said that the US Supreme Court did not understand California law and they got it wrong. And so you see, obviously, that in 2023, we have a steady increase in those PAGA filings going back up. The main claims in PAGA letters that are submitted to the state have been overtime and failure to pay for hours worked. And if you're thinking, oh, well, I don't see meal periods on there, meal periods are usually part of the failure to pay for hours worked, because employees will claim that they were interrupted or had some other meal period issue. And it was while they were off the clock, and they did work while they were off the clock during their meal period, and they were not paid for that time. So that's actually, though it says failure to pay for hours worked, it encompasses the meal periods as well. More importantly is the graph on the other side there, figure 2. This shows you how much the state has recovered in PAGA lawsuits since 2016. So from 2016 to 2019, the amount recovered, the average there is about 42 million. So you can see, obviously, in 2019, the state got $88 million in revenue from PAGA cases. It is a huge money generator for the state of California with very little expenditure, because all they do is they have a few employees for the LWDA, and they have an online portal. And so as a result of this, if you want to go to the next slide, you can see that the LWDA is probably the most profitable agency in all of the state of California. So this is from the 2022-2023 governor's budget, and these numbers are in the thousands. So if you see any numbers here, you add 3 zeros on, and that's really what it is. So where it says looks like 70,000, it's actually 70 million. So what this basically tells us, and I've highlighted, I'm not expecting anyone here to be a financial, budget expert. The important number here is that there is a loan. So that third highlight on the left-hand side, there's a loan from the Labor and Workforce Development Agency of $107 million to California General Fund. So they're taking the money from the LWDA and loaning it out to other agencies within the state of California. So the legislature doesn't really have a desire to make this go away, because it's helping keep the state funded and keeping a lot of different things running. Meal and rest break claims, these continue to be very highly litigated. They are a sweet spot for the plaintiff's bar, in particular meal periods, because they are recorded and they are off the clock, and it is a records-based claim. So the attorneys that are suing companies, they don't need to talk to anybody to be able to determine if there's a meal break issue. They just need to look at the records frequently. And I put a donut because who doesn't want to think about donuts on a Friday afternoon? California's regulations regarding meal and rest breaks make compliance very, very difficult. I would say it is nearly impossible as a company in California to be 100% compliant, no matter how hard you try. And the courts have made it even more difficult because they have said, usually in a lawsuit, if a person sues somebody else or company, it is the person suing who bears the burden to prove that they have a valid claim. But in the context of meal and rest break claims, if you're an employer and your records show non-compliant meal periods on their face, or your policy for rest breaks is not valid or has to remain on the premises type language in it, then the burden actually shifts to you as the employer to prove that what the employee is alleging is wrong. And that is, something that's very unique to cases in the employment realm, that it becomes the defendant's obligation to show that they're innocent. Instead of being innocent until proven guilty, it's assumed guilty until you prove that you're innocent, essentially, which is a very difficult burden to have to overcome. So when I'm talking about non-compliant meal periods, I want to just be clear what I mean. So a non-compliant meal period, we'll talk about the requirements, but it is a meal period that is after the 5th hour of work. It is less than 30 minutes. It is not duty-free, or there's some other restriction put on the meal period that makes it non-compliant. And so when we're talking about a meal period that is short, that could be 29 minutes instead of 30 minutes. And if a person is clocked out, it's going to show on their records that they were clocked out for 25, 26, 27, whatever the exact minutes are. And if it shows that it's less than 30 minutes, again, that presents an issue. And I have a case there for you in case anyone wants to become, a legal expert as a side gig to HR or running a company. You can go ahead and take a read of that. So in Donahue, which came out in 2021, the court said basically, it's the California Supreme Court, you can round time in the state of California. It is risky, but you can never round meal periods. So if you have a timekeeping system that you're using that currently is rounding your meal periods, you want to go ahead and stop doing that. You need your meal periods to be exactly to the minute. So if someone is clocking out at 12:01 to take their meal, it should reflect that they're clocking out at 12:01. Rest break requirements. So rest breaks are those paid on the clock 10-minute periods that we have to provide to our employees. And it is a 10-minute rest break per every 4 hours worked or major fraction thereof. So if you have someone working a 3-hour shift, they're entitled to one 10-minute paid rest break. Now, if you have employees that have to wear some sort of protective equipment, or there's any sort of donning or doffing of, whether it is a mask or, they have to wear a protective vest, anything that they have to take on and off in order to go into rest break, they have to be able to take all of that off before the 10 minutes start. So that's usually the tricky thing with rest breaks. If you're in a manufacturing plant, for example, where you have to, take off the PPE that you're wearing for manufacturing purposes, all of that needs to be done before we start counting the 10-minute period. IKEA many years ago had a class action lawsuit that involved their 10-minute rest breaks because the stores are often very large for IKEA, and employees would say they were told to take their 10-minute rest break while they're on the floor. But in order to get out of the store and actually begin their 10-minute rest break, it took them an additional 5 minutes just to exit the store. So you have to build in, possible travel time if you have a large facility and those sorts of things. The other thing with rest breaks is they need to be uninterrupted and they need to be a full 10 minutes. You do not need to record them, and I generally do not recommend that you record the start and stop times of rest breaks unless you are going to be regularly auditing and paying rest break premiums. It's a record that California law does not require you to keep. keep. And I know some clients that I work with really like to keep that record, but if you are recording and keeping track of people taking their rest breaks, you also need to be doing the flip side of it, which is making sure that they're taking compliant rest breaks.
So Amber, regarding interruption, that means employees can't even receive text messages or any form of communication during their breaks. Is that correct?
That's correct. With the exception that you can write in your policy. Now, policies are really important with rest breaks. So you can write in your policy that, for example, if somebody has a radio or a smartphone or a work device that they keep with them for communication purposes, you can tell them in the policy that they're not required to keep that on during the rest break. In fact, you should have that in your policy if they have to keep a communication device with them. And then if they do it, it's not that the employer required or wanted them to. But yes, it needs to be a full 10 minutes free of any control of the employer. And that includes, it used to be very common for rest break policies to say that they had to stay on the premises because, you can't leave many work sites and be back within 10 minutes, right? And we had a case come down about 4 years ago that said, nope, that's not okay. That's not relieving them of duty. They need to be free to do whatever they want, including leaving the premises. Now, our meal period requirements are a little more tricky than our rest break requirements. So for all hourly employees who work more than 5 hours in a workday, they have to be provided a minimum of 30 minutes of uninterrupted, unpaid time for a meal period. I always get the question, does it have to be unpaid? It doesn't have to be unpaid, but most employers choose not to pay it. But even if you are an employer who is deciding to be generous and to allow employees to take paid meal periods, they still have to be a full 30 minutes and uninterrupted, even if you're paying. That paying for it doesn't change the other obligations that you have. Now, employees may voluntarily choose to waive their first meal period if they're going to complete their workday within 6 hours. But if they're going to work 6.01 hours, that's right, 6.01, 6.1, whatever decimal you're carrying their time out to, if they are on the clock for even a minute over the 6 hours, you now have a meal period violation and the waiver is not valid and you need to pay the meal period premium or penalty. Employees may waive a meal period if a written waiver is on file. You should have a written meal period waiver if you consistently have 6 hour or less shifts. Typically, I would say running up to the 6 hour mark is a little dangerous. It's better to have maybe 5.5 or 5 hours and 45 minute shifts, because then you have a little bit of leeway. And then if you have that waiver, there's no requirement that they take a meal period. And you also need to make sure that employees may revoke the waiver at any time.
So Amber, a question that we get a lot here is on the meal waiver forms, and essentially on the nature of the waiver being voluntary. Are there any general guidelines on how employers or supervisors should really make sure that voluntary means voluntary?
Yeah, so there's two types of waivers, and we've talked about one, which is the 6 hour. The second is a second meal period waiver. So if someone is going to work more than 10 hours but less than 12, they can waive that meal period. Now, if you have both of those shifts in your business, I would recommend you have separate waivers for each because the requirements are a little different. But you should have a written waiver, and the written waiver needs to make it very clear, like bold letters, that this is voluntary. It can be revoked at any time. And that also means in practice, if somebody comes up to their supervisor and says, hey, I'm going to be working, 10.5 hours, 11 hours, but I really need to take a meal period. It doesn't matter that they have a meal period waiver on file. They have just verbally told you that they wish to revoke it, and you cannot require that the revocation be in writing. So if they verbally tell you that they want to revoke it, you have to honor that. So that means that your mid-level managers really need to be trained and understand if an employee communicates that to them, that they have to honor it.
Right.
So employees who work more than 10 hours in a workday have to be provided a second meal period, also uninterrupted, unpaid, at least 30 minutes of time. This is one, like I was just talking about, where you can voluntarily choose to waive the second meal period if you're going to complete it within your shift within 12 hours and you're not going to exceed 12 hours. Just like the 6-hour mark, the 12-hour is a hard mark. So if they go to 12 hours and 5 minutes, you now need to pay them a penalty because they didn't take a second meal period, but they exceeded 12 hours. And that waiver is also, the second meal period is only validly waived if they took a compliant first meal period. So if they had a non-compliant first meal period, they cannot waive their second meal period. And employers often get like really tripped up about this, but what I will tell you is you should likely have some automatic triggers set up in your time and payroll system that are telling you when an employee has not taken a compliant first meal period and second meal period for that matter. But if it's already been triggered, the penalty for the first meal period, there is only a requirement, even if an employee was entitled to 3 meal periods in a shift because they worked that many hours. If all 3 of those meal periods were non-compliant in some way, the maximum penalty for meal period violations per shift is 1. So even though we have 3 violations, there's only 1 meal period penalty that is due. And my recommendation here is obviously that you put your waiver in writing. So just a couple of examples here to kind of drive the point home. An employee clocks in for work at 7:55 a.m. Maybe the shift doesn't start until 8 a.m. The employee has to begin their meal period no later than 12:55. And I use this example because if we have people clocking in, 5 minutes before the start of their shift time, and we have scheduled their meal period to take place at 1 p.m. here, there would be a violation, right? So we have to be aware not only of when they clocked in, but what time does that mean that they need to start their meal period? So here, if we had scheduled employee to take a meal at 1 and they waited until 1, we have a violation that we as the employer caused. This is also why I frequently recommend that we don't schedule our meal periods to start right if we're doing scheduling of them. Don't schedule them to start right at the 5th hour. Maybe schedule them to start at 4.5 or 4 hours and 45 minutes, because that gives you a little bit of leeway in the event that someone has clocked in a few minutes early. If an employee clocks out for lunch at 12:01 and then clocks back in from lunch at 12:30, we have 29 minutes there, not 30. So that is a short lunch, and that would be a violation. It's a technical violation. Technical violations will still be looked at by a plaintiff that is suing you as a violation. Doesn't matter if it's 29 minutes and 30 seconds, 29 minutes and 52 seconds. They just say, hey, it's less than 30 minutes. The law is 30 minutes. And so anything less than that is not compliant. And generally the courts and administrative agencies have agreed with them in that respect. Employee clocks in at 11:30 and clocks out for lunch at 4:31 p.m. That is also a late lunch. And so you would need to be paying a premium for that. And then I have the example here of that second meal period issue. So employee takes a late first lunch. They start their lunch at 5 hours and 5.5 hours into their shift. They then attempt to waive the second meal period during an 11-hour shift. That second meal period actually cannot be waived, and you would need to pay them a premium based on that. So my number one recommendation with respect to meal and rest break claims is to pay premiums sometimes. So you're required to pay a premium at the regular hourly rate for non-compliant meal or rest breaks. And the regular hourly rate may be different than a base hourly rate. So that's something to also be aware of. You may have a base hourly rate of $20 an hour, but you may provide a bonus. For example, if somebody has perfect attendance for the pay period, no lates, you may pay them maybe a $10 per pay period bonus. That promised $10 per pay period bonus actually increases their regular hourly rate of pay. And it may only be by a few cents, but it does create an increase, and you have to pay the meal period premiums and rest break premiums at the higher rate. And so this additional hour pay, it's usually referred to as a penalty or a premium. I think there are a couple of bullet points there if you just want to have them all. There you go. So I just have to say, please pay some premiums, because there was a case back in 2015 involving Safeway, a big company, sophisticated enterprise. They had a division that was part of a class action lawsuit where they had never paid a meal break premium. And it went up to the Court of Appeal, and the Court of Appeal said, oh, there's one explanation for this. Safeway is perfect. Human perfection. The court went on to say how human perfection is very rare, and basically said that would be ridiculous. That they were perfect and no one ever took a late or short meal period was ridiculous. So you need to be paying premiums every once in a while, so that if and when you do get a charge through an administrative agency or a lawsuit, that you can say, but we did pay premiums, even if it's not a lot. We did pay some. We paid them whenever the records showed, whenever an employee told us. So you want to be paying them sometimes. And it's a very, another court has commented on this recently, and they said, unfortunately, we've created a perverse system where we're encouraging there to be violations so that there's a record of paying premiums, and they're not wrong. You should be separately listing the premiums on the wage statement. So you should have a separate line item for those, not just lumping them into the regular hours that are worked. Lockouts and auto deducts are something I put on here because they're a question that I get very frequently. A lockout is where we have our timekeeping system set up in a way that we don't allow employees to clock back in from their meal period until the full 30 minutes has been exhausted. And auto deducts, we're not actually recording the time that people take their meal periods. We're just automatically deducting half an hour and letting them take it whenever they want. Auto deducts are permissible, but a big no-no in my mind if you want to avoid being sued. And if you are doing an auto deduct, you still need to record the start and stop time of people's meal periods. So I would say if you're doing an auto deduct, you're running in a very high risk category. So that's like in the red area of risk. Lockouts are probably more between the yellow and the red. They're definitely not in a green light go situation. But for some businesses, it's important for them to have lockouts in order to control labor costs. If you are using a lockout feature, you want to make sure that you have some protocols in place to allow employees to report times where they went back to work and were not able to clock back in due to a lockout.
Yeah, and for those listening, in the Timeero app, we have a way of restricting people. Once they start the break, we have a way of restricting them from ending their break until they take, for instance, for 30 minutes. You can't really go back in and have the clock ticking again until your break ends. And generally we do, when our customers or folks reach out to us, in California, we generally tell them not to use the auto deduct. It just ends up creating a lot more problems for them.
That's right. And the lockouts, like they can be used. I think it's important just to communicate to employees that in the event they are in a period of lockout and an emergency happens, or they're called back to work for some reason, that they just need to report that and we'll take care of it. So it's really that lockout feature is just, it requires very clear and consistent communication about how to report when there's deviations. The best practice for meal periods is to track the actual meal period, start and stop time, to regularly audit those records, run reports at the end of the payroll cycle, and to pay premiums when they're due.
Amber, I had a quick question.
Sure.
Amber, so what we do on our end when we pay premiums, because we do pay them all the time, we list them right on the employee time card. Is that not recommended?
It's fine for them to be on a time card. Yeah, but they should also be on the wage statement.
Okay, so on both. Okay. All right, thank you.
So why are we always talking about wage and hour issues? Again, here we have Mr. Justice telling us why we're always talking about it. It's because we don't want to be in a lawsuit with him. The last lawsuit I had with him, we went to mediation, and his first demand was, and this was a PAGA only claim of meal periods, rest breaks, and overtime. And his demand was $90 million. So that's why we're always talking about wage and hours, because the amount of money that is sought in these lawsuits is can be astronomical. And for small and mid-sized businesses, it can really be a challenge, because we're often not setting aside, a reserve. Like Walmart has a reserve for litigation. But if you're talking about your average, regional or single location enterprise, we're often not setting aside that type of money. So to give you an idea of how one of these cases looks, so if you have 75 employees and the employees are paid weekly, the damages in a PAGA case, we look at it per employee per pay period. So every check that is issued to an employee when there's a violation results in a penalty. So that's why we're talking about the pay periods when we go through this damage model. So assume that there's one violation for each pay period per employee. The 1 year minimum penalties would be at least $390,000 and as high as $78. I can't say that. $780,000. So it's very expensive. And then typically what happens is we have 4 to 8 separate violations alleged, and they're going to claim that they can stack them. So you would take that 390 or 780 and you multiply it times 4 or times 8. And that is sort of what the worst case scenario looks like. The penalty number does not include attorney's fees that they're entitled to recover, court costs, or if you resolve the case, the administration fees. And now if we take this in a class action where they're able to recover both the wages and some penalties as well. If we're talking about a 75-person crew, so in this example, it's a situation where maybe there's an auto deduct or something else is going on, and 2 days a week, the employees are actually only taking 20-minute meal periods, but they're being auto deducted 30 minutes. We have 75 people in the crew. We have 52 weeks each year. So we have 3,900 work weeks per year times 4 years, because the class action looks back 4 years. So we have 15,600 work weeks in the aggregate. Our average rate of pay is $25 an hour. And then we have employees taking 20-minute meal periods twice a week, but deducting that 30 minutes. So we have 10-minute differential or delta there. So the 10 minutes times twice a week is 20 minutes per week. So when we work that all out, we get down to that equates to 5,200 hours that we failed to pay. 5,200 hours times the $25 per hour is $130,000 in unpaid wages. Not an astronomical number, but the way that the labor code is set up, I call it a pyramid scheme, and the top of the pyramid is the unpaid wages, and then all of these other things get tacked onto it. So I think the next slide shows that. So here you would have that unpaid wages that we just went through of 130,000. There's going to be also a claim of a wage statement violation of 200,000. That's assuming you have 50 employees that work during the covered period for wage statement violations. Those are subject to a 3-year period. That's why I have it being slightly different. And then you have waiting time penalties. So any of your separated employees who are no longer with you, they're entitled to get waiting time penalties because they weren't paid all of their wages during employment. And assuming that we have only 30 of our 75 employees falling into that group, that'd be 180,000. They're going to have meal period premiums for those twice a week times the 15,600 weeks. So we have $780,000 in meal period premiums that are due. We also have a potential rest break claim because usually they're going to say if the meal periods were not done right, the rest breaks were probably not done right either. We're also going to have a PAGA claim usually added on to that, plus your attorney's fees to defend it. We're talking about a number that, you know, we started at $130,000 for a mistake in our timekeeping, and it ends up adding up to be about 2.5 to over $4 million. So what are some of our best practices for meal and rest breaks? The first thing is really going to be those compliant written policies, and our policies and practice have to match one another. And when I'm talking about compliant written policies, I'm talking about your handbooks and postings, everything that you have that's communicating the meal and rest break requirements to your employees. They should be clear and they should be consistent, and you should follow them. You need to make sure that your midline managers, if you're not directly interfacing with your hourly employees, those mid-level managers really need to know and understand the policies and make sure that the practices that they're doing with their team or their crew or the people who are working that day are consistent. You want to have a timekeeping system set up in a way that it's automatically triggering a report and hopefully automatically triggering payment for late, short, missed meal periods. And what you can do if you feel like there's too many of them happening, it becomes a disciplinary issue. Go to the employee and say, hey, employee, you know, I noticed that this pay period, you know, there were 10 days that you worked and 8 of them you had meal periods that were less than 30 minutes. What's going on? And you have to try to figure out what's happening. And if it is that they're choosing to do it, they're violating policy, and you unfortunately have to write them up for that and counsel them to comply with the policies. You should regularly remind, reinforce, and discuss meal period requirements with employees. I would say at least, you know, once a quarter, send out a thing just saying, like, reminding everybody, these are our policies with respect to meal periods and rest breaks. If you have questions, let us know. If you have any issues, let us know. You know, you really need to have systems in place, whether through your timekeeping interface, email, whatever the way is that you communicate regularly with your employees as HR or owners or managers. Make sure that they know that they can come to you and easily report any meal or rest period issues that they may be having. And you want to always encourage them to do so. In California, you can mitigate the risk of that class action where we're talking about 4 years, unpaid wages, all these other things that get tacked on. You can mitigate that risk by having arbitration agreements, and arbitration agreements are something always being litigated in the courts. So you want to make sure you work with counsel to get one that is California compliant and compliant with what the current state of the law is. And the arbitration agreement may also help you mitigate MPAGA, but not always. With PAGA, the judge that is overseeing the case does have the right to reduce penalties under the law. So you want to be able to get that reduction as much as possible. So you have to demonstrate as the employer all of the efforts that you made to comply with the law. Communication, policies that are compliant, all of those things are going to go really far in mitigating, not eliminating, but mitigating exposure that you would have in a PAGA case. And Barima, I'm gonna give it back to you to talk about how Timeero can help with those things.
All right, thanks so much, Amber. I know there's a lot to cover in this, and we'll jump in again and show you what we're doing on our end to really help customers and folks in California stay more compliant. And so in Timeero, for those of you who are customers who already use Timeero, you're already aware of the different things that we're able to do, with our time, mileage, tracking, scheduling, and several different things that we have to offer. But I want to specifically focus on California breaks in general. So we recently came out with California break tracking, and we've built a system in place to make it easy to be very, very compliant. Okay, so we have a way for your employees to track your rest breaks, to track your meal breaks, and on the admin portal, you can go in and configure your account to allow you and your employees to track those breaks. Now, you get to choose which employees you want to track breaks. For instance, if you have folks in different states, if you have employees working in Arizona, they may necessarily not have to track your breaks, but for those in California, you can have you can assign them to your break policy, and they will be presented with the attestation forms to answer whether they took your breaks or not. I touched a little bit on the attestation forms, and I'll cover a little bit on that on the next slide. But in the admin portal, you can see who has taken their breaks. Okay, they get to answer every single day that they work, and you see on your end yes or no, or if they did not take their break, you also see a reason why they chose not to take the break. And you can always have a conversation with them. If you find out that you're repeatedly violating breaks, you can have a conversation with them. But this is a really great way to get a high level overview of all the folks within your company or business, and who's staying compliant or not. Now, one of the things we also do is that we send out automated reminders, okay, to take your breaks, whether it's meal breaks or rest breaks. You can totally rely on our system to remind your employees, and it sends out these reminders based on the number of hours that you're working. So if they're working for, say, more than 3 hours or 4 hours, and you can configure that on your end as well, it will send them a reminder on your phones. By the way, these reminders are through push notifications. It doesn't go through text messages. So employees need to be logged into their mobile app and currently on the clock to be able to receive those reminders on your end. In the mobile app, they'll be presented with what we call the attestation form, and this is where they can fill in or answer the daily questions on whether they've taken their breaks or not. So it shows you the expected number of minutes or hours of breaks that you need to take versus how much you've actually taken. And if an employee chooses no, they'll be asked to put in a reason why they failed to take those breaks on your end. And then one of the things we're coming out with soon, we'd had from a lot of our customers regarding signatures. And so inside the mobile app, employees will have the opportunity to sign every single day. They can apply a signature of their own on every daily sign off that you're taken care of on that day. So in the mobile app, there'll be a way to sign it with your finger. It's not really a new concept. There are many apps out there today that allow you to take signatures, and so that's going to be the same concept within our mobile app. It will be very simple and easy to use. One of the other things we're going to be coming out with is the premium pay, as Amber touched on. Please pay the premium pay, right? And so in Timeero, what we're working on right now is that if employees haven't taken their breaks, we'll be calculating that premium pay for you automatically. And that way you don't have to go on and manually calculate or do all of that crazy math. because we have the data, we can definitely provide you with how much each employee is owed in premium pay. So there's a lot that we're doing, and there's more that we're going to continue to do on our end at Timeero to ensure that you and your business and all your folks are really staying compliant. There's definitely a lot to do, and using pen and paper is a good start, but frankly, it's not a very efficient, scalable, or long-term way to go about this. And so using our system will definitely make your life a lot more easier. And also, as Amber touched on, having that policy in place is very, very, very important. You need to have a company policy in place where you have everything in writing, everything well outlined. And so if you have any questions, maybe regarding your company or your business, or even if you need help with coming up with the company policy, please feel free to reach out to Amber as well. You can see her email on here, ahealy@aalrr.com, and we'll send out a follow-up email just to for the folks who are interested in reaching out to Amber. We know every business is different, every company is different, people do things very differently. We know that firsthand just from talking to our customers. Most of you have all kinds of questions, but in the interest of time, we're not going to be able to answer all the questions that we have. But if you have any questions specific to your company or to your business, please feel free to reach out to Amber. Again, her email is on here. And if you have any questions regarding Timeero and things we can do to help make your lives easier, feel free to reach out to us. We have our phone number on our website. You can shoot us an email at hello@timeero.com, or just give us a phone call. We'll be more than happy to talk to you about your needs. Again, Amber, thank you so much for joining us on this webinar and giving us a lot of info on this. We know there's a lot to this, and it seems it can be very confusing and very intimidating. But we really, really appreciate your time, and thank you so much for everyone else who joined this call. And you all have a great day.
Everybody, have a good weekend.